Hello, friends. It's a privilege that Taxman has invited me to speak about the recent decision of Supreme Court in the case of Ashish Agarwal, which has created certain doubts or controversy in the minds of taxpayers with respect to the reassessment notices under Section 148 of the Income Tax Act. It would be my privilege to dispel and clarify this decision in this video. Friends, this decision has two aspects which requires consideration. One is the exercise of power under Article 142 of the Constitution by the Supreme Court in deeming notices issued under Section 148 after 1/4/2021 as notices under Section 148 of the Act as amended by the Finance Act 2021. That's the one aspect of this decision. And other is on the merits as to what extent the Supreme Court has reversed the decisions of High Court which had quashed such notices issued under Section 148 with a liberty to the revenue to issue notices under Section 148 in accordance with law. As part of my discussion, I'm reserving my comments on the power of Supreme Court under Article 142 because that's a bygone, and we will focus on what is the result of the decision on merits of the matter as to how this decision will pan up issues of notices under Section 148A in times to come. What is the effect of the deeming fiction of 148A versus 148? Now, friends, before I come to the nitty-gritties of the decision, if I were to be asked what is the sum and substance of the decision, I would say that it would be a misnomer to say that Supreme Court has reversed the decision of the High Courts. Supreme Court has only partly allowed the SLP filed by the revenue, and when we see the decision in detail, they have only modified to some extent the decision of High Court, and to large extent, if you ask me, in my view, they have confirmed the decision of High Court, and I'll give my reasons for the same in the subsequent part of this video. But friends, what the Supreme Court has done is it has sought to strike a balance between the rights of assessee and revenue, and I'll give my views on it in detail in subsequent part of this video. Before I come to discuss in detail the decision of Supreme Court, it would be pertinent to recap the background behind this entire controversy. Friends, we all are aware that India as a nation struck with the pandemic of COVID, and therefore government has to pitch in to provide timelines to both assessee and revenue wherever they were getting time burnt in that difficult period. So one such act was taken by the government was in extending time limits for the revenue to issue notices under Section 148, which were getting time barred in that pandemic period, which fell on 31st March 2020 and 31st March 2021. The government had originally came out with an ordinance whereby the time limits getting expired in that period were extended. That ordinance was substituted by the Enabling Act, which we call TOLA, Taxation Ordinance Law Amendment Act, which extended the time limits in that intervening period. Originally, by virtue of that act, the time limits to issue notices under Section 148, which were getting time barred, which got time barred on 31st March 2020, were extended up to 31st December 2020. Now, after this notification under TOLA extending the time limits to 31st December 2020, Finance Bill was introduced, whereby the entire regime of doing reassessment under Section 147 was substituted, whereby time limits to issue notices were substituted. Some were reduced, some were extended. Reduction was to the extent of 3 years, and wherever the income escaping assessment exceeded rupees 50 lakhs represented by undisclosed asset, the time limit was proposed to be extended to 10 years, subject to certain further limitations, certain conditions. And one more important thing which was introduced was an entire new provision of section 148A, which provided opportunity to both the assessing officer as well assessee to conduct an inquiry and see whether the information relating to income escaping assessment in possession with the assessing officer was correct or not. This was through issue of notice, show cause notice under section 148A, which was in the nature of a preliminary inquiry, which provides the assessing officer to share information in his possession with the assessing officer, seek his comments whether or not that information is really resulting in income escaping assessment, and on satisfaction of the assessing officer pursuant to reply of assessee, that the notice under section 148 could be issued. So this was amendment by the Finance Act 2021, which became effective from 1/4/2021. This act was promulgated and was assented by the President in the month of March 2021. After the act was promulgated, the executive again exercised its power under section 3 of TOLA and came out with a notification extending the time limit to issue notices under section 148, which were getting time barred on 31st March 2021 to 30th June 2021. Now, apart from extending the time limits, that notification also contained an explanation which provided that notices to be issued after 1/4/2021, they will be issued under the unamended act that existed prior to amendment by Finance Act 2021. That is, in a way, executive by the explanation provided that amendments by Finance Act 2020-21 will need to be ignored and notices can be issued under the old law between 1/4/2021 to 30th June 2021. And accordingly, notices under section 148 under old law were issued by revenue across the country. All these notices were challenged by the assessees before several high courts. The statistics show that in that period, approximately 90,000 notices were issued, which were challenged across the country before various high courts. Now, different high courts took a view that while the executive had power under section 3 of TOLA to extend the time limit, but it had gone beyond the statute as amended by Finance Act 2021 in asking the AO to issue notices under the old law. It was to that extent that the courts came down heavily on the executive and held notices so issued under the old law to be bad in law, and those explanations were struck down or partly modified or read down. So that was the total case which was before the high courts, which was challenged by the revenue before the Supreme Court in SLP. It was not that all the matters or all the decisions of High Court were challenged before the Supreme Court. It was only the decision of Allahabad High Court where only few SLPs were filed, and then the various petitioners which were falling in the jurisdiction of Delhi intervened before the Supreme Court in that matter. The Supreme Court in this decision, lead decision reported as Ashish Agarwal, did not went into the merits of the matter. They did not decide upon whether or not the executive had power in TOLA to issue the notification, whether they had the power to supersede the amended act and asking the AOs to issue notices under section 148 under old law. They did not went into that controversy at all. On request of the learned ASG representing the matter on behalf of revenue, the Supreme Court invoked its power under Article 142 to strike a balance between assessee and revenue, because the plea of the revenue was that what had happened, it was only the lapse of procedure on the part of assessing officer and it was argued that it was a bona fide lapse. The country was still suffering from COVID pandemic. There was time and again extensions, and which had led to a bona fide mistake on part of the revenue in not following the new procedure. It was only the lapse or not following the correct procedure as was recently amended by the Finance Act 2021. So the Supreme Court, without going into the merits of the matter, have invoked its power under Article 142 to partly allow the SLP of the revenue and has only partly modified the decision of High Court to some extent. What the Supreme Court has held is that I'll take, friends, now to support this, I'll read certain critical findings of the Supreme Court which are contained in para 7 to 8 of the Supreme Court order, which will clarify all the doubts in your mind and help us in understanding what is the correct ratio of this decision. So Supreme Court, after discussing the entire legislative history behind the old scheme of section 147, the new scheme of section 147, and what the notifications, how TOLA had issued notifications, made its observations at para 7 of the Supreme Court order. I'll take the liberty to read certain portions from that decision. Para 7. Thus, the new provisions substituted by the Finance Act 2021, being remedial and benevolent in nature, and substituted with a specific aim and object to protect the rights and interests of the assessee, as well as, and the same being in public interest, the respective high courts have rightly held that the benefit of new provisions shall be made available even in respect of the proceedings relating to past assessment years, provided section 148 notice has been issued on or after 1st April 2021. So Supreme Court in this particular para has affirmed the decision of High Court that they were right to hold that since the new provision is remedial and benevolent in nature with the aim to protect the public interest, the notices after 1/4/2021 could have been issued only under the new law. Therefore, they have held that the procedure was applicable retrospectively even to assessment years, even to earlier assessment years. So they have in a way upheld the decision of High Court that the amendment being procedural in nature is applicable retrospectively to earlier assessment years as well, and held we are in complete agreement with the view taken by various high courts in holding so. So in this para, friends, the Supreme Court has upheld the decision of High Court. Now we move forward. Para 8. However, at the same time, the judgments of the several high courts would result in no reassessment proceedings at all, even if the same are permissible under the Finance Act 2021 and as per substituted sections 147 to 151 of the Act. So they have held that while the High Court is right that new procedure ought to have been followed, but their decision have resulted in no reassessment proceedings even in cases which were possible under the amended Finance Act 2021 and as per substituted provisions of section 147 to 151 of the IT Act. The revenue cannot be made remediless and the object and purpose of reassessment proceedings cannot be frustrated. So they have held that just because the department is not able to follow the new procedure, the revenue cannot be made remediless and the object and purpose of reassessment proceedings cannot be frustrated. It is true that due to a bona fide mistake and view of subsequent extension of time-wide various notifications, the revenue issued the impugned notices under section 148 after the amendment was enforced with effect from 1/4/2021 under the unamended section 148. So they held that since the timelines were being time and again extended by the executive through issue of notifications under TOLA, there is a possibility of a bona fide mistake on the part of assessing officer in not following the new procedure and issuing notices under the unamended act under the old law. Then the finding of the Supreme Court in the same para. In our view, the same ought not to have been issued under the unamended act and ought to have been issued under the substituted provisions of section 147 to 151 of the IT Act as per Finance Act 2021. So they have held that yes, revenue could not have issued notices under the old law, but should have issued under the substituted provisions of section 147 to 151 of the Act as per the Finance Act 2021. There appears to be genuine non-application of the amendments as the officers of revenue may have been under a bona fide belief that the amendments may not yet have been enforced. So they were attributing bona fide mistake on the part of officers. Therefore, finding of the Supreme Court, therefore we are of the opinion that some leeway must be shown in that regard, which the high courts could have done so. Some leeway needs to be given to the revenue officers. Therefore, instead of quashing and setting aside the reassessment notices issued under the unamended provision of IT Act, the high courts ought to have passed an order construing the notices issued under the unamended provision of the IT Act as those deemed to have been issued under section 148A of the IT Act as per new provision of section 148A, and the revenue ought to have been permitted to proceed further with the reassessment proceedings as per the substituted provisions of section 147 to 151 of the IT Act as per the Finance Act 2021, subject to compliance of all the procedural requirements and defenses as are available under the new law. And thereafter, the Supreme Court promulgated 5 action points. That is, the notices under section 148 will be deemed as notices under section 148AB. That is, the information shall be provided to the assessing officer. Reply will be filed by the assessee. On satisfaction of that reply, the assessing officer will pass an order under section 148AD, and all the defenses and rights available to both assessee as well as the revenue under the amended provisions of section 147 to 151, more particularly including the time limits contained in section 149, shall be available to both the assessee and the revenue. So friends, this is the decision of Supreme Court, where they have only partly modified. They have, in substance, they have upheld the ratio of the decision of the High Court that procedural law has to be applied retrospectively. The High Court was right in holding that after the amendment, the notices could have been issued only under the new law. But the Supreme Court held that where even under the new law, notices could have been issued and the assessing officer on bona fide mistake because of time and again extensions and confusion of passing of the act and issuance of notification by the executive under TOLA, they issued notice under the old law. They, by exercising power under Article 142, they deemed that notice to be a notice under Section 148A. But they have given all the rights and defenses as are available under Section 149 and other provisions to these notices. Therefore, these notices are to be only deemed as notices under Section 148A. Now, friends, these are only notices under Section 148A. 148 notices are yet to be issued, and time limit under 149 is capping the time limit to issue notice under Section 148, which is yet to be issued after due compliance of the procedure under Section 148. So that time limit of 3 years or 6 years, as the case may be, would still be available to the assessees. So therefore, where the case is less than 50 lakhs, the revised time limit of 3 years will be applicable. If notice after the inquiry under 148A, which is a deemed notice under 148A, is completed and notice is to be issued in 2022, let us say in the month of June 2022, then the date of issue of notice under Section 148, my friends, in my view, will be June 2022 only, and 3 years, time limit of 3 years will be counted from the date of that notice. So therefore, unless wherever the notices were stayed by the High Court, if that period is to be excluded, then the time limit will be counted as being expired on 31st March 2022. 3 years will be counted from that date, subject to the period of stay given by the High Courts wherever the notices were challenged. And if the case falls beyond 50 lakhs, subject to the condition of undisclosed asset, only in those cases, the revised time limit of 6 years will be seen, which is to be counted from 31st March 2022. So therefore, it is possible that assessment years up to AY 14-15 would get exhausted because they are clearly falling beyond the period of 6 years, subject to removal of the period of stay wherever the writ petitions were filed, and vice versa. So friend, this is in sum and substance the decision of the Supreme Court, which we should not consider has reversed the decision of High Court in toto. or to revive all the notices issued under Section 148. The liberty, the rights of the assessee in challenging the limitation under Section 149 is still available. They have only revived the notices which could have been issued under the amended law. The extended time limits under TOLA, etc. have all gone. Only those notices are considered as 148A notices. 148 notices are still to be issued, and the assessee has right to challenge those notices as per the time limits contained under Section 149 of the Act. This is broadly my endeavor today was to discuss broadly the decision of Supreme Court. What are further niceties of that decision, whether or not our case will fall within the revised time limits or not, that are matters of detail which can be discussed on seeing the relevant file. But yes, friends, we should not get swayed by the fact that decisions of the High Court have been reversed or your notice has been revived. You should see the validity of that notice in light of this revised decision of Supreme Court, and see and raise your defenses before the assessing officer to see whether or not that notice falls within the time limit or not. So thank you, friends. I hope this would throw some light on this discussion, and if my view is correct, then it will help in raising relevant defenses before the assessing officer in challenging the notices issued under Section 148 after 1/4/2021 and as per the decision of Supreme Court deemed as notices under Section 148A of the Act. Thank you, friends. Thank you for patient listening. Thank you so much.